Hi, good morning, everybody. Thank you so much for joining the class today. As Pascal mentioned, if you have any questions, please feel free to put them in the chat and I'll answer them as I go. Today's class deals with how to successfully represent the buyer of a business. A lot of realtors are not aware that you don't need a special license to represent somebody either buying or selling a business. And it's actually, we do a lot in our office because there are no forms that you can use. So a lot of the documents that need to be prepared are attorney prepared, and that's something that we do. So I'm gonna share later, I'll get everybody's contact info and I'll share my slides and some other information. Now let me get started. So here's a little outline of what we're going to discuss: why buyers should sign a non-disclosure agreement, how the purchase of a business in Florida can lead to a U.S. immigration visa and actually residency as well, the importance of a letter of intent to buy a business, understanding the asset purchase agreement, what happens during the due diligence period, and the essential steps to a business closing. And of course, the use of non-compete and non-solicitation agreements when buying a business. And we'll discuss that in that order. So first, whenever you are helping somebody actually list a business, whenever you're listing a business, you are going to be providing private information that that business owner has: who their vendors are, who their suppliers are, who their customers are, how they do marketing. All these things are going to be very valuable to the potential buyer. So of course, the seller doesn't just want to give this information out. And you as agents should advise the seller to work with an attorney to draft a non-disclosure agreement. This is even before there is an offer presented, anything. This is the first document that should be signed by a buyer so that whatever is disclosed during the potential offering of the business, the buyer cannot just take that information and go and set up their own business and basically steal all of the intellectual property and the information that the seller has. So an NDA, or non-disclosure agreement, or confidentiality agreement, is a legal contract in which a party promises to protect confidentiality of a secret that is disclosed to him or her for a certain amount of time. This is something that we use a lot whenever we're representing somebody buying a business. We expect for our clients to sign a non-disclosure agreement. When we are representing a seller, it's something that we draft and we inform the agent that that needs to be signed by any potential buyer. And even in other situations, like when you're trying to enter a joint venture agreement, whenever you're disclosing any information that's valuable to you, you would want to have a non-disclosure agreement signed so that they cannot use that information unless it's with you in that transaction. We sometimes do mutual NDAs for certain situations because we also don't want, if the buyer is providing some information, we may want that protected as well. So it will depend. So again, a non-disclosure agreement, why is it needed? Because in a business transaction, it's important for a potential buyer to see also the financial records. If you have, for example, a single member LLC, and that single member LLC doesn't pay taxes as a corporation, but it pays regularly as a single member LLC, they don't even do their own tax return. That tax return, it's part of their personal tax return of the seller, and nobody's going to want to provide that information unless there's a non-disclosure agreement signed. So again, NDA ensures that any buyer who's giving access to financial or proprietary information disclosed by the seller will not disclose that information to any party who also has signed a non-disclosure agreement, or they can actually disclose it to their CPA or their attorney because they also have certain fiduciary duties with that information. What do you have in a non-disclosure agreement? It's very important that you have the location, the name, and the type of business, the length of time. So how long is this NDA going to last for? I usually put it for 2 years, but it depends on the transaction. You also want to have a list of who is party to this non-disclosure agreement and what information cannot be disclosed. So maybe they're showing the financial records, the contract with the staff, with the suppliers, the customers. So you want to be specific as to all of this information. You cannot disclose it to anybody else or use it unless it's within this transaction. Sometimes, and I have seen this in actually litigation, people will go and pretend they want to buy a business just so that they can get all this information and use it for their own business. And that is why this non-disclosure agreement is extremely important for the seller to have signed by the buyer. And if a buyer tells you they don't want to sign it, then that must be a little suspicious, because why don't they want to sign it? Are they just using you to get the information of the seller to set up their own business? That's what I would think. So it's so important also, especially because we're in South Florida, to understand that buying a business can also lead to an immigration visa. You guys as realtors can use this to advertise your services, that it's not just buying a business. It's actually, you may be able to get the American dream. And I'm going to talk to you quickly about 3 different types of visas and residency that somebody can apply for through the purchase of the business. First, we have the L1 visa. Then we have the E2 treaty visa, and I'm sure you guys have heard of the EB5 immigrant investor visa. These are the visas that somebody could apply for through the purchase of a business if it meets certain requirements. So for example, the L1 visa. This visa allows a foreigner who works at a company abroad to come to the United States, work in a company here that has a certain corporate relationship with the company abroad, and be able to apply for an L1 visa and eventually residency and citizenship. This includes their spouse and their children under 21. One of the basic requirements is that whoever's coming with an L1 visa, they must have worked for 1 year out of the past 3 years in the company abroad. And then the company in the United States, that's actually something that we set up. We set up the company in the United States, and we ensure that it meets that corporate relationship with the foreign company so that they can use the company to acquire any business. Any business will qualify for an L1 visa as long as that business has at least 6 or 7 jobs or has the ability to create 6 or 7 jobs. Because for this particular visa, we have to show that whoever's coming is either an executive or a manager, and that they oversee maybe 1 or 2 other professionals, and then under that, the people that actually deal with the public. A great business for an L1 visa that I've seen is, for example, daycares. Why? Because you're going to have a director, you're going to have teachers, and you're going to have teacher assistants. So that you already have that organization and you're able to apply for an L1 visa. But in reality, any business would work. I have clients that have bought restaurants. I have clients that set up hotels. I have clients that set up marketing companies. And, as long as it's a business, as long as there's some amount of investment, I would say 150,000 jobs created, and this person has worked for 1 year out of the past 3 years in the company abroad, then you would be able to apply for an L1 visa, which you get for usually 1 year and a maximum of 7 years. But after the first year in the United States, that person is able to apply for permanent residency and eventual citizenship. Okay, so this is a great visa that leads to residency and citizenship. We talked about the qualifying relationship. Then we have the E2 visa. This is a visa that we do a lot more than the L1 visa because it doesn't require that you have a business abroad. This visa is for anybody that wants to buy a small restaurant, a store, or wants to set one up from scratch. Basically, one of the basic requirements is that the person that's applying for the E2 visa, they have to be from what is called a treaty country. Okay, so there are certain countries that have special treaties with the United States, and only citizens of those countries are able to apply for an E2 visa. I'm Peruvian. Peru doesn't have a treaty, but we have been able to do E2 visas for Peruvian. How? Because they have double nationality. For example, Colombia has an E2 treaty. So we're able, if you're Peruvian, but you also have the Colombian citizenship, you're able to apply for an E2 visa. Brazil doesn't have a treaty with the United States for an E2 visa, but we've actually done a lot of Brazilians and helped them achieve E2 visas because a lot of them are Italians, are even Spanish. Spain has it, Italy has it. Venezuela also doesn't have a treaty with the United States, but we have helped many Venezuelans apply for E2 visas because they have Italian citizenship, Spanish citizenship. So as long as the investor has that citizenship of a qualifying country, treaty country, they're going to be able to bring their whole family, even if they don't have that citizenship. So let's say there's a husband and wife, and the husband, they're all Peruvian, but the husband has Spanish citizenship. So just because he has Spanish citizenship, even though the rest of his family don't have it, they're all going to be included in an E2 visa. The person that applies for an E2 visa, it's only allowed to work for the business that they're setting up or that they're buying, but their spouse is able to work wherever he or she wants, and their kids are able to go to public school here, no problem. One of the other requirements is that whoever is applying for the E2 visa, they have to own at least 50% of the business in the United States. Now, they can own all of the business, but at least 50% and be in control of that business. The length of stay, it's going to depend on the country. Usually it's 5 years, and you can keep on renewing this visa indefinitely. So as long as the business is going forward, you're going to be able to renew this visa. All right, another visa that we can also apply for, that this one, it's straight residency and then eventual citizenship. It's called the EB-5 visa. This visa has a specific requirements. It requires the creation of 10 full-time jobs, and it requires also a certain amount invested. Right now, that amount is $1,050,000 or $800,000 if it's a rural area or an area with high unemployment. So if we have a rural area or an area with high unemployment, the investment amount is $800,000. Otherwise, it's going to be $1,050,000. Now, for this particular visa, there are two ways to do it. One way, it's through a regional center. And all right, so there's two ways to do this visa. One is through a regional center. So regional centers are private institutions. They are not the government, but they have received a designation from immigration to receive foreign investor money and give it to projects. Those are the buildings that you see built. Those are all the projects that you see. They should be working with a regional center. So because these projects are working with a regional center, the investor doesn't have to worry about the job creation. The project does the job creation, and they have specific formulas. Also, the project doesn't need to be where the investor plans to live. Let's say somebody wants to live in South Beach, but they want to invest in an EB-5 project in Houston. Not a problem, because they don't have to manage that business. They're basically just giving their money and that's it, and waiting it out. The laws have changed, and now if you come in with a visitor visa or you're here on a student visa, when we apply for the EB-5, we could also apply for adjustment of status, which is great because it gives you status while you're here, and you don't have to wait until it gets approved for you to be able to apply for residency. You can do it with the application. That's great. Recently, the laws have changed, so we love it. The other way to do an EB-5 visa is you yourself or the investor buys a business. And that's where you guys come in, because the investor is going to have to buy a business of at least $1,050,000 or $800,000 if it's a rural area or an area with high unemployment. And it can be any business that you can find for $1,050,000, or maybe the business is $900,000, but then they invest capital to make it to $1,050,000. Okay, that's the magic number. And job creation. So if the business already has 10 full-time jobs, you cannot use those jobs. You have to create 10 new full-time jobs, okay? So if the investor wants to do it on their own, meaning not through a project, then they're going to be responsible of creating those 10 full-time jobs, and they're also going to be responsible of managing the business. So you cannot say, I'm going to live in South Beach, but my business is going to be all the way in North Florida, because how are you going to manage the business? And that's the requirement of immigration. The money is invested, the jobs are created, and that the investor actually manages the business. For any of these visas, you can help them buy a business. And as long as it meets certain requirements, it's going to qualify them for a visa. EB-5 is a great one to do because it's straight residency, but L-1 visa also leads to residency. E-2, the business for the visa of E-2 does not lead to permanent residency. However, I have clients that started with a business, they invested maybe $300,000, then later they invested $400,000, and they made it to the $1,050,000. We can now use all of that investment to now apply for EB-5. So they're here on E-2 because they started with a small amount of money, but eventually they got to the $1,050,000, and now we're able to use that money that they invested to apply for an EB-5. So even though E-2, the E-2 visa doesn't lead to residency, there are other ways, such as converting it to an EB-5. Another way is also if the spouse is working in any job and the spouse receives what is called labor certification that from their job, then they're going to be able to apply for permanent residency. And when they do apply for that, all of their family is going to be included. Had the spouse not been able to work legally in the United States, maybe they would have never received that opportunity. So that's another reason why people apply for E-2, so that their spouse can study or work here and then be able to apply for residency eventually. All right. Any questions about visa so far? I don't see any questions. Let's talk about the letter of intent. So now we're back to buying a business. So you guys as realtors are not supposed to be drafting documents that are not prepared already by the Florida Bar and by your realtor association. You will not find a form letter of intent. So what I've done is I have different forms that I use depending on the type of business. And once we establish relationships with realtors, then we help their clients, draft it, because sometimes that deal may not go forward. They may need to present that letter of intent to many different businesses. It just depends. A letter of intent is basically an agreement to agree. It's not the actual contract. It's like a blueprint, bullet points of what is it that we're looking for in this business and what we're offering the seller that we're going to be buying. What is it that we want? So for example, the letter of intent can include confidentiality clauses. We're going to say that we're going to keep everything that is disclosed to us confidential. Of course, the purchase price, how much do we want to pay? Are we going to pay it in parts? How do we want to manage this purchase of the business? What liabilities would we accept or not accept? We could also put in the list of the purchase assets. And of course, what law governs, how will this letter of intent be terminated? We usually put that the letter of intent is only good until we draft the definitive agreements, meaning the purchase agreement, stock purchase, membership interest transfer agreement, or asset purchase agreement. And I'll explain that in a minute. So all of that is important to put in the letter of intent. And also for you guys realtors, you want to put there your commission so that it's clear that they're paying you your commission, that the seller is paying some type of commission. For the letter of intent, it's going to depend which one we're going to use on how we're going to buy the business. So there's basically two ways to buy a business. One is you just buy the assets of the business. So for example, a restaurant, we would draft an asset purchase agreement and we're just buying basically the goodwill. We're buying all of the assets that business has, but we're not buying the company. The seller is their company, but we're not buying their company. We're only buying the assets. We're going to have to transfer the lease to us. We're going to have to apply for license permits under the name of our company and all of that. That is the most common way to buy a business because nobody wants to. Basically, when you buy a company, you step on the shoes of the seller, and now you're responsible for whatever liabilities they had. If they file taxes, I think the statutory period is 7 years, and the IRS does an audit, you're going to be responsible if you bought the whole company. You stand on the foot of the seller. So not a lot of people do that, but there is another way to buy a business. Sometimes people do it if it's medical practices. Sometimes if it has special contracts they don't want to lose. There are reasons why. If they're buying a corporation, then we would draft a stock purchase agreement and the letter of intent will reflect that. If they're buying an LLC, a limited liability company, then we would draft membership interest transfer agreements and the letter of intent would reflect that that is the intention. Okay, let me see. I see a couple of questions here. Okay, so my contact information is there. If anybody needs it, it's in the chat so that you guys can follow me. I put a lot of educational videos on TikTok and Instagram, so I hope you all can follow me. All right, the asset purchase agreement. This is the most common document. Again, you will not find a form in the MLS, so this is something that we draft. It's basically, it's going to outline everything that we want in the business, right? So we're going to say we want this particular assets. We will assume this liabilities, or we're not assuming any liabilities. Everything needs to be listed. It's going to be including representations and warranties, okay? Because we want the seller to represent that they're selling you stuff, that is free and clear of any type of lawsuit, lien, that they've complied with all the laws, that they own everything. You want to include all of that in the asset purchase agreement. The asset purchase agreement is a document that's going to be there, until the closing, but also after the closing. So we put certain things that say this will be after the closing also, because we want the seller responsible as much as we can if we're representing the buyer. Unlike buying a property, like when you're helping somebody buy a property, there's something called title insurance, right? So title insurance protects the past from the time that we used to have little alligators here to the time that you get the property. So it's a great insurance to have. Believe it or not, only the United States has it. No other country has it. And it protects you up to the amount of the property. And it says that if anybody makes a claim later, like that was my house, I inherited, whatever it was, the title insurance is going to kick in and protect you or provide an attorney to protect you and all of that. It's beautiful. We don't have that when you buy a business. There is no title insurance, right? And I don't know if you guys know, but in Sunbiz, when you go to the Florida Secretary of State, anybody can go online and make changes. So when you're buying a business or you're helping somebody buy a business and you see the names in Sunbiz, maybe they just changed their, a month ago. So how do you know? How do you know that the business is being sold to you, the seller actually owns it? How do you know that it doesn't have any lawsuits, that it doesn't have any liens, that it doesn't have any, that the machines that they're selling you, they actually own them, that they're not leased? Well, all of these things have to be looked at. By whom? By us and the CPA if they do financial due diligence. So due diligence, and this is going to be stated in the letter of intent or in the whatever purchase agreement you're using. You're going to have a period immediately after the execution of the asset purchase agreement or whatever relevant agreement you're doing, so that they can conduct their independent legal research and investigate the validity of the business. This time period is extremely important because there is no title insurance. There's only the due diligence that you do. Usually, and when I'm doing due diligence, I require at least 20 days, okay, for any business. Now we can do it in as little as 10 days. But if we're dealing with businesses that have specific licenses, for example, contracts with Medicare, Medicaid, a lot of medical practices, or vendors that have licensing agreements, if it's more complex, then we would want a longer due diligence period. If we're dealing with pharmacies and things like that, because there might be information that is not readily available and we want to examine everything. So what I particularly do during the due diligence is I look, for example, in the Florida UCC. So it's called the Florida Secure Transaction Registry Uniform Commercial Code. So what is that? Whenever you get a loan, right, secured on personal property, on the assets of the business, on anything like that, they are supposed to record a UCC that says what that loan is encumbering. For example, everybody and their mom got EIDL loans, right? During the pandemic, the emergency EIDL, I forgot what it stands for. Disaster loan, emergency disaster loan, something like that. Anyway, it was loans for businesses so that they can keep afloat. There were two loans. There was the PPP, which actually was gifted to you after if you used it to pay your employees. But the EIDL, that one needed to be paid back. So what happens is a lot of people don't check, and you're buying a business, and that business has this EIDL loan, emergency injury disaster loan from the SBA, and there is a UCC that's recorded that says that they encumber everything in the business. And it's going to say that. It's going to say they encumber the assets, they encumber any potential revenue, everything. And if that's not satisfied, then now you bought a business, but you also bought the loan because the seller cannot sell it to you legally. So it's so important to check for us UCCs to see if there's any type of loan. Whenever somebody gets this cash advances on the business, they're going to record a UCC. Whenever somebody gets any type of business loan, they're going to record a UCC. Whenever you buy equipment, they're going to record a UCC if it's borrowed, if it's being financed. So that's one of the first things that we check. We check the Florida Secure Transaction Registry to see if there's any UCC encumbering under the name of the seller, could be the company, or the individual owners. Because if you don't check the individual owner's name, right? For example, if I get a loan of for my law firm, they might record a UCC against the law firm, but they most likely are going to record a UCC against me too, because they want me personally responsible. And if I don't check the person's name and I say, okay, there's no UCC in the company's name, we may still have an issue because the person put as collateral everything of the business that they own. So it wasn't free to be sold unless that UCC is satisfied. And so if there is a loan, what we do is we get a payoff, for example, from the SBA or any lender, and then that's paid at closing. Before the seller gets a penny, we satisfy any outstanding loans. And that way we make sure that the buyer gets a business that's free and clear. So that's one of the first things that we check. We also check Sunbis, or the Florida Department of State, for any type of judgments recorded, because whenever you get a judgment from anywhere, you're supposed to record it on the Florida Department of State. Some attorneys don't do it. I don't know why, but that's what's required in order for the judgment to be valid. So we check there to see if there's any judgments recorded against the person, the owners, and against the company. We also check the clerk of courts of the county that the business is at. And sometimes we even check the other counties too, because you never know. Why? Because what if there's a pending lawsuit? And now this person is trying to sell you the business. And whenever you're trying to get rid of assets and you have a pending lawsuit, it could be seen as a fraudulent transfer. And there's actually something written about that in the statutes, in the Florida statutes, that doesn't allow somebody to basically get rid of their assets so as not to have money and fraudulently. So we have to check if there's any outstanding lawsuits. We have a special system besides checking the courts, which we do ourselves. But we have this special thing from LexisNexis that only attorneys and I think police officers have access to, that allows us to basically search a person and a business and see any lawsuits that they have, any judgments that they have, any UCCs that they have. Even though we do it manually, we also run that search. It's from LexisNexis. It's called Accurant, and we do that for the sellers and for the business. We want to check all of that to make sure that there's no issues. We also check for the business tax status. This is not the taxes that you're thinking. No. Every business in the state of Florida should have licenses and permits, right? Every business. And sometimes they don't pay certain business taxes in order to have the license and permit. So we check that too. We also check the county tangible tax status if applicable. And I was mentioning we do a comprehensive asset search to make sure that it's fully protected. So all of these things, it's what we do. I don't expect the realtors to do it, to ensure that we're trying to give the seller, the buyer, as much of a clean business as possible. We don't check the taxes. I don't do financial due diligence. That I recommend buyers to hire a CPA, and I have a fabulous one. My husband is a CPA to do that, because you want to get transcripts, right? Because somebody can just give you a tax return and it looks super legal, but in reality, it's not what they give you, it's what they reported to the IRS. So for that, I recommend that they get transcripts when they're doing financial due diligence, that they look at the merchant statements, how much are they selling in credit cards, that they look at the deposits in the bank account, how much money's coming in. And if it's one of those cash businesses, for example, a restaurant, a hair salon, I tell the clients, go and sit there, sit outside, don't tell them you're there, and just see the foot traffic, get to know how the business is, what do they do, so that you do your own due diligence. We don't do the financial due diligence. I highly recommend that they do it, but we do the legal one so that they know as much as they can what they're getting. So again, due diligence is extremely important. Buyers and sellers are free to ask any and all questions to try to complete their transaction. In the event that the buyer finds that the business no longer meets the buyer's needs for any reason, right? The contract should state that for any reason, then the buyer can get their deposit back during the due diligence period. Okay, so it's very important that the buyer gets at least 10 or 20 days of due diligence, that the contract clearly states that the buyer can back out for any reason and receive their deposit back. Don't assume that's the case. I have seen asset purchase agreements or any type of purchase agreement where they don't say that. And then if they don't say that, then the buyer doesn't get their money back. They have a due diligence period, but the money, the deposit, once it's given, it's a hard deposit and they won't get it back. And then they come to me for the litigation. And they're like, Romy, the attorney never told me I was not going to get my deposit. Or sometimes they're not even represented. And they're like, the realtor never told me I wasn't going to get my deposit. I look at the agreement. It doesn't say that they get it back during the due diligence period. So there's really nothing I can do for them. And then they want me to sue the realtor, but I don't like doing that. So I don't do that. All right. So we talked about due diligence. It is so important to have a long period for the attorney to fully do it so that the buyer understands what they're getting. Here now we have the closing process. Of course, we finalize the purchase price. Why would we finalize the purchase price? Because maybe when we sent the letter of intent or when we drafted the asset purchase agreement, we proposed a certain price, but after the due diligence period, we realize that the business is not worth that much. So now we say, hey, we want to adjust the price, or this is what we want to pay, or whatever it is. So we can finalize that purchase price. The way that we do it in the asset purchase agreement, when we're dealing with inventory, we put it there that this is to buy the business, whatever X amount, but this is for the inventory, because it's what's valuable is the inventory. You want to put a number there. And then we say, if during the due diligence, we see that there is not enough inventory to equal this amount, then the price is going to be adjusted down. Okay. All of this is negotiable. Then you can, if you're representing the seller, you can say, no, I don't want that, because there are other people that are willing to buy it for the price that I'm asking. So I don't accept that. All of this is negotiable when the agreements are being drafted. And it doesn't matter what people say, okay? What's going to regulate the transaction is what's written in the actual agreement. And yes, the letter of intent is important, but I was mentioning to you that the letter of intent is an agreement to agree. It's not an agreement. So it's important to put as much as you can in the letter of intent, but it's more important to ensure that everything that was written in the letter of intent goes into the agreement. That I also see in litigation. They come to me and they tell me, Romy, I'm buying this business, but the letter of intent had all this, and now the agreement doesn't have it, and the seller doesn't want to give it to me. But they already signed the agreement. So what's going to regulate is the agreement. And most agreements are going to have something called an integration clause. An integration clause, it's going to say that it doesn't matter what we texted, what we said, what we wrote anywhere else. If it's not in this agreement, it's not going to be binding. And in the case of a lawsuit, the judges, they are limited to what's in the agreement because it has an integration clause. So it's so important, again, to include everything in the agreement. So as we're getting ready to close, and I don't see any questions yet, but feel free to put any. We want to finalize the purchase price. We want to prepare any type of governmental documents if required. We want to ensure that we're meeting insurance requirements. We want to prepare any type of furniture and equipment, make a list if we're representing the seller. If there's any agreements that need to be transferred, we want to look at those agreements and start the transferring process. If there is a lease, this is so important. Whenever you're representing the buyer of a business, or the seller too, but the buyer more importantly, you have to ensure that they have an existing lease, commercial lease, with options to renew. Okay. And that whatever requirements are stated in order to transfer the lease, those are done. Sometimes people buy businesses and they think, oh, I already bought the business, or even they bought the company. Oh, I bought the whole company. So, the lease is binding. And then the landlord comes and says, wait, I didn't rent to you and I'm going to evict you. And then they come to me and they're like, Romy, I bought the whole company. I don't understand how the landlord can evict me, because I look at the lease and it says that any change in ownership of the tenant, because the tenant is a company, it's going to require landlord approval. And if you didn't seek the landlord approval and you bought the business, now you violated the lease, and yes, they can evict you. And yeah, absolutely. So it's important to read the lease, even if you're helping somebody buy the whole company. And if you're helping somebody just buy the assets of the business, that lease needs to be transferred to the new buyer's company. You want to ensure that they have options to renew, because a business is not good unless it has a location. I'm talking about businesses that have locations. So you want to ensure that they have, a period of time in the lease, and then they can keep on renewing. When I'm representing the seller, I want to ensure that the lease is transferred to the buyer, of course, but more importantly, that they release the seller from being a personal guarantor. And don't assume that happens. I've seen transactions on the litigation side. I see all these things on the litigation side, and it's already, already happened. If we would have done it, it wouldn't have happened. But anyway, and basically what happened was somebody bought a restaurant. The lease was transferred to them, but the seller was never released as a personal guarantor. So the people that bought the restaurant, they defaulted on the lease. And what did the landlord do? The landlord sued them, and the landlord sued the seller personally, because they never were released from the guarantees. And all guarantees are going to be what it's called jointly and severally liable. What does that mean? That means that all of you are responsible. And I don't care if I get the money from you or from you, I'm going to get my money, and I can get all of the money from you. So whenever we're representing the seller, one of the things that we ensure is that they are released as a personal guarantor, because we do not want the landlord to come after the seller in the case the buyer defaults. Okay, so very important if you're dealing with the seller. And if you're dealing with the seller, you want to ask a very important question before you list the business. Do you have a valid lease? Sometimes they don't even have a lease. Oh, I've been in this business for 10 years. And yeah, we had a lease at the beginning, but now we don't have it anymore. Then they don't have a lease. The landlord can just come and evict them, and that business is not worth it. So whenever you're representing the seller, you want to ensure that they have a valid lease, or they negotiate for one, and that they have options to renew. And cap on the increase of rent in the options to renew. So that way they have a more valuable business. Okay. So after we've done this closing preparations, we've done our due diligence, we prepare all of the closing documents, such as the bill of sale, the closing statement, we talk to the landlord for the lease to be transferred, then we can schedule the closing, right? So usually the deposit is going to come, if I'm representing the buyer, it's going to come to my trust account, which is an escrow account. And then at closing, I'm going to prepare a closing statement, and attorneys do that. They prepare closing statements like you're used to, the HUD or all of that, which basically is going to say everything that the buyer needs to give me as far as money. What can be included there? For example, if there was a transfer of the lease, there's maybe a deposit that's going to be given to the buyer, it's not going to be given to the buyer. The landlord is going to keep that deposit. So we want the buyer to pay that back to the seller. If there's any outstanding debt that needs to be satisfied, all of that needs to be listed in the closing statement so that those payments go out. Your commissions, that needs to be listed in the closing statement so that when we get the funds, we're able to distribute. So all of this is prepared in the closing statement, and then the seller will know exactly how much they're getting, what they're being charged, so that at closing we have no issue. We finalize the deal. Nowadays, everything is done remotely. We could even do remote online notarization, but if they want to come to the office, it's actually perfect too. So either way would work. The closing is done. If it's an asset purchase, now the buyer through their company owns those assets. If it's a stock purchase agreement, now they own the company. If it's a membership interest transfer agreement, now they own the LLC, and they can continue doing business. If it's an asset purchase agreement, it is so important that they transfer all of the licenses and permits, right? For example, we recently helped somebody buy a cosmetology salon. So they bought a salon, and we did the closing, but we had to apply for the cosmetology license for the salon in the name of the business. We had to apply for the what's it called, for the occupational license at the city level, and for the licenses at the county level as well. So you're always, most of the businesses are going to be regulated in three ways: at the city level, at the county level, and at the state level. So depending on the type of business, you might need to do it longer. It might take longer to get certain licenses. Like if it's a restaurant, they might need the alcohol license. You may be able to start the process before you actually close. For example, when they're buying a restaurant, everybody's going to have to be fingerprinted. So you may be able to get those things done. So whenever you're helping somebody buy a business, make sure that you talk to the attorney. Hopefully it's me, but if not, talk to the attorney and say, hey, listen, this business has certain licenses. What can we do before we close so that as soon as the buyer buys it, they're able to keep operating? So all these things are things to look at when you're representing somebody buy a business. Don't assume the licenses are going to stay, because they're not, if they're just buying the assets. Even if they're buying the company for a restaurant, for example, when the ownership change, all of those owners, new owners of the company, they need to be fingerprinted. Otherwise, they're violating the Florida laws regarding alcohol beverage, which can even be a criminal thing. So be really careful with that. All right, as part of the closing process, we want to ensure that the seller signs the following documents: the non-competition agreement and non-solicitation agreement. I'm going to talk about that in a minute. But another very important document that we make the seller sign, it's called the seller affidavit. Besides the purchase agreement, it's a seller affidavit that we make them sign individually and as president of the company, as many sellers as we can, whoever owns the company, because it's what's going to allow the buyer to sue them in case they lied. So we make them sign and assure that there is no liens, that there is, no lawsuits that they know of, that they don't know of any complaints from any employees, as many things as we can make them swear so that we can hold them responsible later. Okay, so we do that, and that's called the seller's closing affidavit. Now, the non-competition agreement and the non-solicitation agreement are also very important. And I don't know if you guys know, but in April, the Federal Trade Commission, the FTC, issued a ruling that basically banned all non-competes with certain exceptions, okay? So why? Because they said that non-competes restrict the ability of somebody to earn a livelihood, which is true, it does, okay? That was in April. If nothing changes, it's going to go into effect September 4th. September 4th, most of non-competes are no longer going to be valid. And actually, if you sign a non-compete, your employer, it's supposed to notify you that the non-compete is no longer valid. Anyway, I have another class on the notification and all of that. But I want to make a distinction. One of the non-competes that will continue to be valid is the non-compete signed by sellers of businesses. Why? Because think about it. You're buying this business, let's say the salon, right? And the seller goes, sells you the business, and opens up a salon 2 blocks down. Not even, I don't know, 20 blocks down, wherever. Calls all their clients, hey, I move locations, come over. So now you have a salon with no clients. Oh, and no hairstylist either, because they're all going to go with the seller. See, that's unfair, because you, as the buyer of the business, you are paying for this business, for the clients, for the employees. You're paying for all of that. So you want to ensure that's protected. And those non-competes, the ones signed as part of selling a businesses, those are still going to be valid even after September 4th, because the FTC realized that that's important. To sell a business as a buyer, you want to be protected. So typically a non-compete agreement is a contract between an employee and an employer where the employee agrees not to enter into competition with the employer after the employee terminates or is terminated. Those no longer valid, with certain exemptions for high-end executives, something like that. However, in a business sale, the buyer should strive to have the seller sign one for the same reason, so that the seller agrees not to enter into competition with the buyer for a certain period of time and within a specific mile radius of the business, right? So what we usually do, depending on the business, of course, this has to do with the business, is how much of a non-compete do we want? Because they still have to be narrowly tailored. You can't just be crazy, right? So if it's a salon in Broward, then maybe my non-compete will say the seller cannot open up a salon in West Palm Beach and in Miami-Dade. Or, if it just depends on the business and what they agree to, but you could say, a mile radius. You could also state the period of time. Maybe you're not going to compete for 2 years, but after 2 years, I don't care if you compete, or maybe you won't compete for 5 years. or forever. Well, forever is too crazy. Maybe 5 or 10 years, something like that. You also want to make sure that the non-compete says the seller individually, but also indirectly. Because yeah, what if I don't compete, but then I put my husband to compete? Same thing, or my cousin or something. So we put it so that it's seller, directly, indirectly, through their family. Nobody can compete. So that's very important when we're drafting a non-competition agreement in the sale of a business. We also want a non-solicitation agreement, okay? A non-solicitation agreement is a contract in which an employee agrees not to solicit a company's clients or customers for his or her own benefit or for the benefit of a competitor after leaving the company. However, in a business sale, the same applies. It should be signed by the seller in order to ensure that he or she will not solicit any of the previous clients or customers for his or her own benefit. And we could also include employees there. We don't want them to go and solicit the employees that are staying with the business because that might affect your business. So these two documents, very important. Even after September 4th, they're still going to be binding when we're dealing with the sale of a business. Okay. Well, there you guys have my contact information. I don't know if anybody has any question. Somebody says, I remember that the rule non-compete agreement was repealed last year. I was just explaining that as of, it was April, that the FTC said, we're going to issue this ruling, this is what we want, and it's going to be effective September 4th. There is, of course, a couple lawsuits there, but if nothing changes, as of September 4th, the other non-competes are not going to be binding in the employee-employee relationship, except with certain tiny exceptions. But these non-competes, the one dealing with selling a business, that one is going to be binding. So that one has not stopped. Alrighty. I don't see any more questions. Let me see. Oh, would that include subcontractors for non-solicitation? You could include whatever you want in the non-solicitation agreement. And if the seller agrees, then that's what it is, right? So it could be drafted, and as long as it's written properly, it's going to be enforced. Let me see any other questions. Well, let me tell you a little bit about me now that we're ending. I'm an attorney. I do not just this business sales, but we also do everything that deals with litigation, trademarks, copyright, estate planning, probate, real estate. And believe it or not, all of that may come into play in the business sale. I hope you guys see me as a resource. I love helping the realtor community. So if you guys have any questions, all my contact information is there. If I can be of any assistance to either you or your client, feel free to reach out to me. It was really a pleasure. I hope everybody enjoyed the class, and I'll see you next time. Thank you so much. Bye.